Hi, everyone. Thank you for joining us. It takes just a minute for everyone to get into the webinar here, so we'll go on mute for a few seconds and be right back with you. Okay, I think we can get started. I want to thank everyone for spending some time with us on this Monday night. My name is Tony Wilkin Gibbart. I'm Executive Director of Midwest Environmental Advocates. And for those of you who don't know, MEA is a nonprofit environmental law center that combines the power of law with the resolve of communities facing environmental injustice to secure and protect the rights of all people to healthy land, water, and air. I also want to introduce my colleague and coworker at MEA, Rob Lee, who's a staff attorney with us. Rob will be talking with us in just a minute here. Thanks for joining us, Rob. And again, I want to thank everyone for spending some time with us this evening. As you know, we want to focus on opportunities before the Wisconsin Supreme Court. With the election of Justice Janet Protasiewicz, there is increased attention in the state and even nationally on our state's Supreme Court. So we'd like to spend some time talking with you about the role that the court plays in environmental protection and some issues that may come before the court in the next few years. To do that, we're going to start by just providing some basics about the Wisconsin Supreme Court. Many of you may know it's a seven-person or seven-justice court, that it is the highest court on matters of interpretation of state law, and the justices of the state Supreme Court are elected to 10-year terms by the voters of the state on a staggered basis. When there is a Supreme Court election, it occurs in April. And those April elections, because we're not voting for governor or president as we are in the November elections, tend to be lower turnout. And I think it's fair to say that historically, the state Supreme Court elections have been very low turnout elections relative to other elections. And indeed, that the candidates have been less, or the electorate has been less informed about the differences between the candidates. However, this last April in the election, we saw record turnout, and we saw the two candidates for Supreme Court Justice starkly divided in a public way on some very significant issues. Justice Protasiewicz won that April election in what was widely considered a landmark and landslide victory, and she was seated on the Wisconsin Supreme Court at the very beginning of this year during an investiture ceremony on August 1st. So before we go any further here, we'd like to just say a word about this nomenclature, this framework for talking about the court, liberal justices versus conservative justices, and what that means for environmental protection. And of course, as you know, the impetus for this webinar is the election of Justice Protasiewicz, and many are talking about the significance of her election in terms of the liberal justices now gaining a majority on the state Supreme Court. Certainly, there is some explanatory power to this language, and we will use it to talk in a general level about the court. But there may be this idea that, well, liberals tend to support in better environmental, stronger environmental regulation, and conservatives tend to take the viewpoint of the business community. So maybe it's the case that liberal justices will tend to side with environmentalists on cases involving the environment, and the conservatives would side with business interests. That's why we want to sound just a note of caution here that can be an overly simplistic view for trying to predict how the court will decide any particular case. And actually, to do that, we have a perfect illustration of the court making a ruling on two important environmental cases from 2 years ago in 2021, when the conservatives controlled the court with a 4-3 conservative to liberal split. Rob, why don't you take us through these two cases since you were involved in them?
Thanks, Tony, and good evening, everyone. It was a real pleasure to be here with you all to talk about these important issues. Yeah, in July 2021, the Wisconsin Supreme Court issued decisions in two high-profile environmental cases in which MEA participated in some capacity. So the first case in which MEA uh, represented five impacted residents. That involved a challenge to a water pollution discharge permit that DNR issued to a concentrated feeding animal operation called Kinnard Farms up in Kewaunee County. And the permits were challenged for a lack of conditions that, one, imposed an animal unit cap, and two, the lack of a condition requiring a groundwater monitoring network. The second case in which MEA participated as friends of the court and filed a brief on behalf of Central Sands Water Action Coalition involved a challenge to 8 permits for high capacity groundwater wells that DNR had evidence would together create adverse cumulative impacts to surface water, a constitutionally protected public trust resource, right, in the area. And so these cases, these two cases, again, being considered by a conservative majority on the court there, were treated as companion cases, but because they both involve the application of a law known as Act 21 that was passed early during the Walker administration, and that requires DNR to have explicit authority from rule or statute to impose conditions in permits. So you can see the language right there in the screen from Chapter 227. And so DNR had basically taken a Attorney General opinion from former AG Brad Schimmel, stating that DNR did not have explicit authority, right, to either impose those conditions in the Kinnard Farms permit or consider cumulative impacts, right, to surface water sources from groundwater wells. There, they took the AG's opinion and ran with it and didn't consider those cumulative impacts in the high cap case or those conditions in Kinnard Farms, and were sued for both of those cases. So both of those instances. So just given the high profile nature of the case, which is really interesting here, is the Wisconsin legislature, which we all know has been dominated in recent years by Republicans, in part through gerrymandered maps. They used the authority that it granted itself in the December 2018 lame duck session before Governor Evers and Attorney General Call took office to intervene in both of these cases and argue against DNR's authority. Yet, nevertheless, despite strong opposition to government regulation from the legislature, regulated entities, and powerful industrial groups like Wisconsin Manufacturers and Commerce, DNR's authority and duty to protect the environment were vindicated when current Chief Justice Annette Ziegler joined the liberal minority of the court, comprised of Justices Dalit Karofsky and Ann Walsh Bradley, and ruled in favor of environmental protections in those cases. So just moving to the next slide here, I think the takeaway, though, for those two things, as Tony pointed out, right? Here we have two environmental issues that on the surface we may expect to break a certain way given the composition of the court, but in fact, just the opposite occurred here, right? They actually ruled in favor of upholding these environmental protections in both cases, right? So both MEA, our clients in both cases, and our partners such as Clean Wisconsin, who worked really hard on both cases, want to acknowledge them. We were successful, even though there was that conservative majority, and many of the groups that support conservative candidates were on the opposite side of the case. Now, it's not to say that the makeup of the court decides, definitively the case one way or the other, but it's certainly a major role in the outcome of cases. But we can't forget, right, the other factors that can play a role in how cases are decided too, including, for example, example, the extent to which the legal issue may be open to multiple interpretations or not, and how the litigants have framed the issues and developed facts throughout the litigation, right? What sort of posture is it before the court there? But I think these two cases too also underscore just how important the state Supreme Court is in deciding these significant issues of environmental protections. And that's because those issues turn not on federal law, where we may think of some of our bedrock environmental laws come from, right? But those issues turning on state law, right? And really the nuts and bolts of environmental protections in Wisconsin does come down to state law. And the state Supreme Court is the ultimate arbiter of that. But even then, those other landmark federal environmental laws that I alluded to, right, such as the Clean Water Act, the Clean Air Act, those are oftentimes, and certainly in Wisconsin, delegated to the state to operate and be implemented through state statutes and regulations. So oftentimes it is the state Supreme Court rather than federal courts that decide the most consequential cases involving the protections of Wisconsin's natural resources. So with that, I'll turn it back to Tony.
Thanks a lot, Rob. It's great to get those 2 points on the table. And with that, we can turn to our main topic. We'll discuss ways that the Supreme Court may be significant by deciding issues that relate to environmental protection over the coming period. And to do that, we're first going to talk about a few specific legal issues that we think are likely or possible to come before the court. And then we'll talk about several overarching trends that have negatively impacted the state's ability to implement and enforce environmental protections in the state and the positive role that the state Supreme Court can play moving forward. So, actually, with that, I'm going to turn it back over to Rob, who's going to talk about a foundational issue, access to the courts.
Oh, yes. One of the most riveting issues in all of law, standing to bring cases and mount a lawsuit at all, right? So certainly standing is an important issue and a fundamental issue, right? Because it is a threshold question of whether you can bring a case in any capacity on any issue, environmental or not, right? But the law of standing does decide which people and groups can bring lawsuits to vindicate which environmental rights. Environmental cases are often challenges to the action or inaction in certain instances of government agencies like the Wisconsin Department of Natural Resources. And the standing criteria can therefore determine, right? Again, who can even sue that agency for an action or inaction, and has a fundamental impact, right, on the outcome of any litigation. And they simply determine, as a practical matter, what types of cases can be brought and whose interests are represented in court. So there has been some recent developments in the law of standing here in Wisconsin, and I think that is best exemplified by the case in which those developments took place. So that's the Friends of the Black River Forest case that was decided last year by the Supreme Court. So I'll discuss the facts of the case and then discuss how the conservative majority arguably narrowed the law of standing with its decision in this case. And we'll also highlight, just real quick for you, what the liberal justices said in their dissenting opinion, right? And what not only this case, but what the liberal justices said might mean for environmentalists' access to the courts moving forward. So this case, Friends of the Black River Forest, is a case in which the Friends here challenged a DNR decision to swap a parcel of state parkland in Kohler Andrea State Park with a nearby parcel of land owned by the Kohler Company, who is attempting to build a golf course adjacent to the park up there in Lake Michigan. And in that case, the Friends asserted standing based on their recreational, conservation, and aesthetic interests in the park parcel to be swapped. And these interests are often recognized by courts at the state and federal level as being sufficient to establish standing here, as those interests are often within what they say the zone of interest of certain statutes protecting environmental rights and interests in the environment. So, despite that, the conservative majority of the court at that time found that the Friends did not have standing to challenge the land sale. The court had reviewed previous cases that define standing to sue in environmental cases, and the majority opinion argued that certain language, being that phrase zone of interests in previous court decisions, was not grounded in the statutory text that establishes standing. There, it requires that persons be, quote, aggrieved. So specifically, the majority found that language in previous decisions, right, purporting to grant plaintiffs standing to sue whenever the environmental harm to those plaintiffs, again, in the zone of interest protected by the statute, was unsound. They found that approach unsound. Then, where they arguably narrowed the standing test, they decided that whether or not a plaintiff has standing hinges almost or exclusively on whether the plaintiff has a, quote, legally protected interest, right? And what that means is the statute, right, that is that's, let's see, alleged to be violated or giving rise to the cause of action, right? That statute must protect the interest being asserted, right? That's what it means to have a legally protected interest, and it must do so explicitly. And so the court found that none of the laws regulating state parks that the Friends had pointed to protect their asserted interests, those aesthetic, conservation, environmental interests in that park parcel. And therefore, they did not have a legally protected interest and didn't have standing to sue. And the case, therefore, was dismissed. Now, in the dissenting opinion, joined by the 3 liberal justices, there's heavy criticism of the majority opinion for engaging in, quote, a hollow label change, that is changing standing from zone of interest to legally protected interest, and that this change in labels only obscures the subtle insertion of another, more exacting atextual limitation. Still quoting from the dissenting opinion here, they wrote, "The law plainly grants the Friends standing to seek judicial review of the DNR's actions that the Friends allege were unlawful and harmful to its members. Yet a majority of this court prefers to slam shut the courthouse doors and reworks the law to reach its desired result. The majority reworks the law by distorting case law and failing to engage in any meaningful interpretation of the legislative text." So what does that mean moving forward? We have a binding precedent, right, articulated by the conservative majority in the Friends of Black River Forest case, right? But we have the liberal minority dissenting in that case altogether, right, saying that they got it wrong. So that'll certainly be interesting to see how a newly constituted court treats that. It's important to recognize, though, that Friends of the Black River Forest, they didn't explicitly overturn any of those previous cases. They just, again, took that more subtle approach to claim that, oh, no, all of the relevant previous decisions are consistent with our view here. And we're just changing the nomenclature used for the standard here, really. But interesting, though, a little bit more, another point is that Justice Hagedorn, who wrote a concurring opinion and had a deciding vote in the Friends case, suggested that he was open to further reconsidering standing law in light of arguments that were not made by parties in this case. So it's a little bit unclear what the enduring impact the Friends case will have. It's certainly binding law that is being cited by the Court of Appeals in cases right now, right? But the dissenting liberal justices may now have a fourth ally to undo, in their words, the slamming of the courthouse doors to environmental and conservation groups like the Friends of the Black River Forest. Tony?
Thanks, Rob. Great summary there. The second issue that we're going to talk about relates to energy transition. And I think it's fair to say that energy transition, the transition from fossil fuels to renewable energy, is one of the most pressing issues of our time. I think it's also fair to say that Wisconsin has been slow to adopt at the rate of other states, renewable energy and solar energy in particular. And that is in part due to specific legal and policy issues that we're facing here in Wisconsin that have slowed the deployment of solar and created economic barriers to rapid deployment. One of those issues that I want to bring up is actually related to a case that MEA is currently litigating on behalf of 350 Wisconsin, a climate change group. And actually, it's a set of cases before the Wisconsin Public Service Commission in which two major electric utilities are proposing to lower the rates at which they will reimburse customers that install solar panels on their property and return that energy to the grid. Those reimbursement rates are generally called net metering rates. And there's a lot of evidence to show that low and inconsistent net metering rates in Wisconsin are one of the reasons that we have been slower in deploying solar across the grid. Another key issue, and this is the main issue that we want to talk about, is a lack of certainty, of legal certainty, as to whether third party financed solar installations are even legal in Wisconsin. Third party financing are arrangements where typically a solar developer will pay for the upfront installation cost for a homeowner or a business or a municipality, and then lease that installation back to the property owner while energy is returned to the grid. Clean, renewable energy is returned to the grid. And these arrangements can be a really important way that those customers can afford to install solar, and a key way that we will develop a cleaner, a more equitable, and more resilient grid. Now, the problem in Wisconsin is that utilities take the position that any third party financed solar installation meets the legal definition of a public utility. And as a result, they're subject to the same legal regime that utilities or companies that you and I would think of as public utilities, like Madison Gas and Electric or We Energies, are subject to. And therefore, it's impractical for third party financing to be approved if that legal interpretation holds. Um, in recent years, the Public Service Commission, which governs in this area, which is the agency responsible for oversight, has disallowed third party arrangements, citing this legal uncertainty. More recently, the PSC actually approved one proposal, but then denied another. So while things may be headed in a good direction at the PSC to broaden third party financing, there's still extensive uncertainty in this area. And many commentators think it's likely that state courts will ultimately decide this issue because they don't see the legislature stepping in to resolve it. And it's possible that one side or the other, solar developers or utilities, will bring this issue of statutory interpretation to the courts. And it is possible that the state Supreme Court will be the ultimate arbiter of this really important issue. If that happens, whatever way this issue is decided, certainly will have a big impact on the speed and the scale of energy transition in our state. And so it's one of the issues that we see on the horizon. A third issue that we'd like to talk to you about that is also on the horizon relates to the court's method for interpreting the state constitution. And the state constitution, like the federal constitution, guarantees certain rights to the people, and some of those rights relate to a healthy environment. Most notably, and perhaps most directly, the public trust doctrine is grounded in the state constitution in Article 9, Section 1, which states that the waters of the state shall be common highways and forever free for us, the people of Wisconsin, and for the citizens of the United States. And based in that statutory or in that constitutional provision, rather, the courts have found that the public has certain affirmative rights to use and enjoy the waters of the state, and the state, in turn, has affirmative obligations to protect those rights on behalf of all of us. So this is just an example of how constitutional interpretation can bear on environmental rights. And when it comes to constitutional interpretation, some very recent Wisconsin Supreme Court decisions show fracture lines in how the conservative and liberal justices might approach constitutional interpretation in the future. Generally speaking, in the recent past, the conservative justices have grounded their constitutional inquiries into what they believe or uncover as the original meaning of the state constitution as it was intended by the framers of the state constitution. They look to historical evidence to guide this inquiry. And that general philosophy is called originalism because the judge is supposedly trying to discern the original meaning as it was understood at the time the Constitution was drafted and adopted. In contrast, or at least with some difference, in two cases from this last year, Justice Dallet, one of the liberal justices, has issued dissenting and concurring opinions in which she argues that originalism is not the only way to interpret the state constitution, and that the previous court decisions using an originalist methodology are not binding and will not be binding on future state Supreme Court decisions. And in one of those opinions from Justice Dallet, she writes, quote, most of the Constitution's key provisions are vague and deliberately so. In writing these open-ended clauses, the framers weren't trying to settle every legal question that might arise under these provisions for all time. Instead, they were trying to create a document that would endure by providing a political platform wide enough for considerable latitude in which future generations could make their own decisions. And in this passage and others in these opinions, Justice Dallet does appear to be signaling that the liberal majority is open to returning to a more holistic analysis of constitutional interpretation. She says that the Constitution's text and history, of course, need to be considered carefully, but then, quote, also one needs to consider precedent, context, historical practice, and tradition, and the need to balance the majority's values, that is, the majority of the people, their values against the values that should be protected from society's majorities. Okay, why is any of this relevant to environmental law? And I alluded to this earlier, but that's because many, if not most, of the significant environmental issues that we face today, when we think about climate change, when we think about emerging contaminants, when we think about widespread contamination of the state's groundwater, those issues could not be imagined by the framers of the state constitution in the 1848 period when the Constitution was adopted. And to the extent the state constitution's rights that relate to a healthy environment are going to have any relevance for Wisconsinites today and endure, quote, forever in the terms of of Article 9, Section 1, then that means that judges' inquiries into the Constitution can't be limited by what they perceive the imagination or the thoughts of a very narrow segment of society that lived in the mid 1800s. And again, the public trust doctrine is a really key example of this. In order for the rights to water that are protected by the doctrine to be meaningful for us today, we have to consider our current context. The fact that we use water in ways much different than they were used in 1848 should not render the doctrine's guarantees any less meaningful for those of us today. Okay, so we want to now shift gears and talk less about particular legal issues and discuss some overarching trends that are likely to be addressed by the court in the coming years. And these are trends that by and large have been mostly negative. They've threatened the state's ability to implement and enforce environmental protections, but the court could play a positive role moving forward to ensure that environmental protections are faithfully executed and implemented in Wisconsin. So the first such trend that we want to discuss involves unprecedented changes in the structure of state government. And these changes have shifted the balance of power between the legislature and the executive in ways that make it more difficult to enforce environmental law. So to take a quick step back and appreciate Wisconsin's rich and long legacy of environmental protection that has existed in the state and is reflected in laws that were passed over the decades and that are still on the books. As a result of our state's value of fresh water and natural resources, we have some of the most forward-looking and powerful environmental laws anywhere. But we want to talk about how the implementation of those laws has been eroded. And this has all occurred in what I'll kind of refer to here as the gerrymandering period, and we'll talk about gerrymandering in a minute. But that period from 2011 to the present was a period in which this balance of power between the branches was dramatically changed, again, negatively impacting the enforcement of environmental law. And through as gerrymandering was a state of affairs and the legislature became the least accountable branch of government, it found ways to make itself the most powerful branch. And that gave polluters and allies in the legislature the opportunity to grab power and to make it more difficult for the state to implement and enforce our environmental laws. Often doing this through power grabs that gave committees of the legislature power that has traditionally rested with agencies. Now, these power grabs undermine the very structure of environmental law. And that's because almost all environmental laws are premised on agency implementation over time through processes like rulemaking, where more specific and detailed regulations are promulgated and updated, and permitting processes, where environmental standards are brought to bear through permit conditions on entities that are proposing ways to alter the environment. And the important thing to realize is that this kind of agency discretion was part of the design of our bedrock environmental protections because legislatures understood that they themselves were poorly suited to constantly be updating environmental laws to reflect changing conditions, to apply facts on the ground, and to respond to new science. And so they created processes where agencies were empowered to make these changes. And if agencies can't carry out those activities, the laws don't actually work as they're intended because the on the ground protections don't reflect changing conditions. They don't reflect new contaminants. They don't reflect a changing climate. Um, so there was a commentator from Marquette Law School, Professor David Streifling, who talked about some of these changes to administrative law, and he called them, this is back in 2017, the quiet revolution in Wisconsin administrative law. Um, Quoting from his 2017 article, in Wisconsin, the past 5 years have seen an unprecedented makeover in longstanding principles of state level administrative law. These changes shift power away from agencies and towards the courts, the legislature, and the governor. And Professor Strickling wrote this in 2017 before the 2018 lame duck laws, which dramatically took more power from the agencies and the governor and the attorney general and gave it to the legislature. How does this relate to the Wisconsin Supreme Court? Well, generally speaking, the previous majority on the Wisconsin Supreme Court either helped drive or went along with these unprecedented changes that have weakened the enforcement of environmental protections in our state. And the Kinnard and High Cap Well cases that Rob talked about earlier on from 2021 are actually the exceptions to the rule. One key example of the court condoning these kinds of unprecedented structural changes is the SCIU case from 2019. And again, that's another case that Rob participated in. So, Rob, why don't you tell us about this case?
SEIU Local 1 v. Robin Voss, who, if you didn't know, is the Speaker of the Wisconsin Legislature. So this is a 2019 case decided early in the days of Governor Evers' administration, in which the Supreme Court reviewed several challenges to those lame duck laws that we've been talking about here. That again were enacted right after Governor Evers and AG Call were elected, but before they were inaugurated. And as Tony's been saying, in many ways, the lame duck laws gave the legislature a much bigger role in the implementation and execution of laws, including in lawsuits, right? I already mentioned the power that they gave themselves to intervene in virtually any case, right? I think the standard is involves the constitutionality of a statute or the construction of a statute. So if a judge is going to interpret a state law, the legislature can intervene in that case, right? And that's a big power grab of something that's traditionally been left to, for example, the Department of Justice that litigates on behalf of the state, not the legislature, and the Department of Justice being part of the executive branch, not the legislative branch. So two more examples on that. I started at the bottom there, as you probably see, but rulemaking authority. Now we've seen them through all sorts of legislation, right? The legislature limit or make the rulemaking process extremely more difficult. But with this legislation, the lame duck laws, that the legislature gave a single committee, right? It's a joint committee, but a single committee comprised of a subset of the legislature, the power to suspend promulgated administrative rules. And when I say promulgated, I mean they've been enacted, they are the law, and it allows them to suspend them and essentially make them no longer the law and potentially indefinitely. There. So that's a big issue there that interferes with the executive's ability to implement state statutes through its administrative rules. In addition to that, the legislature has also required that virtually all settlements, right, and actions that DOJ is prosecuting and that DOJ or the Attorney General negotiates also be approved by a single committee of the legislature. And so on all three of these issues, whether it's the rulemaking suspension or JFC's involvement in settlements in cases or legislative intervention into cases, which are just three examples of the types of power that they gave themselves. But in all three of those examples, the conservative majority sided with the legislature and ruled that the legislature's transfer of power from the executive to these committees in most instances passed constitutional muster on their face. And what does pass it on their face mean? Means that they found at least one constitutional application of those new statutory provisions. However, the conservative majority did allow that there may be other applications of that, right? In certain instances where those new lame duck powers may be found unconstitutional. We just haven't gotten there yet, but certainly those issues could come before a new court. So the opportunity here, right? We certainly know how the previous majority tended to view this issues, but with the new majority, there's an opportunity, right, for the court to uphold Wisconsin's environmental laws, but in doing so, to apply what we've come to know as our traditional separation of powers principles, where the previous majority declined to do, so that the state, right, and duly elected governors and their administrations can faithfully execute and enforce the laws that protect our water, land, and air. Now, the conservative majority had shown a willingness to go along with some of these unprecedented changes that obstruct the ability of the state to faithfully enforce environmental protections. And in most jurisdictions, federally or in other states that also have the separation of powers principles instilled in their constitutions, many of these power grabs would be seen as clearly unconstitutional. And so the new court likely will see a number of cases in which fundamental issues, including some of those presented in the lame duck laws, about the role of agencies and the executive versus the legislature, will be presented and potentially decided. And so it will be up to the courts, including the Wisconsin Supreme Court, to uphold the laws as they were designed and intended to be implemented. And it does bear mentioning that this is a significant environmental issue, that quiet revolution that Tony was talking about, right, has been underway, and at least in part is designed to mute the effectiveness of environmental laws that have been politically popular, but to do so in a way that has as little political fallout as possible. So it's very interesting issue there, and we'll see how the court deals with those moving forward. So now we're just going to transition real quick into another issue, that could come before the courts in the future, and that's special interest litigation and strategies that special interest groups have to weaken the ability of the state to implement and enforce environmental protection. So I'm going to give you two examples of cases, one that's a couple of years old and a little further along, and one that was just recently filed, but both that were filed by a very powerful special interest group called Wisconsin Manufacturers and Commerce, and both cases that might very well be ultimately decided by the Wisconsin Supreme Court. And again, this is a part of a litigation strategy that is trying to achieve policy changes that would be politically very unpopular. So these two cases are one, Wisconsin Manufacturers and Commerce versus the Department of Natural Resources. In fact, so that case there is also known as the spills law case, is what I call it. And the other case is one in which WMC is not a party, but their litigation center is brought on behalf of two other organizations in which they're challenging DNR's authority to require any CAFO to have a water discharge permit. But rather than vindicating WMC's litigation strategy, the court can actually turn these efforts around and vindicate the these bedrock environmental laws and ensure that they continue to protect the environment and public health here in Wisconsin like they always have. So this first case I want to talk about, the spills law case. You heard, I think Tony mention perhaps earlier the spills law, but it's a very important law that's been on the books for approximately 45 years now and has done its job quite well and has been humming along protecting the environment and public health for quite some time until WMC mounted this challenge. And so WMC suing DNR over its implementation of Wisconsin's spills law. That law designed to protect environment and public health from discharges of hazardous substances and require parties responsible for those spills to do what we know you always have to do when you make a mess, clean it up, right? So WMC is alleging that DNR is required to establish standards for every hazardous substance, each and every possible substance that could be hazardous, before regulating them under the spills law, even though that has never been required in the 45 years that the law has been on the books. And why? Because the legislature saw fit to define that term or that phrase, hazardous substances, broadly, to include any substance, no matter what it is, that poses a threat to the environment or public health based on the specific properties of that substance, the concentration and volume at which it's discharged, and other site-specific circumstances surrounding the discharge. And so WMC is pointing as an example in this litigation to a highly toxic emerging contaminant called per and polyfluoroalkyl substances, also known as PFAS for short, even been nicknamed forever chemicals just because of how nasty these things are. But they pointed to DNR's application of the spills law to discharges of those substances as an alleged unlawful implementation of the spills law. But I mean, right now, the spills law, right now, it's out there working, right? And it is absolutely vital to impacted communities all across the state, but particularly those faced with PFAS contamination, because there's just so few other regulatory hooks on the books right now to regulate those substances and protect both the environment and public health. And there is no doubt, right? There's no argument that PFAS are toxic, right? Pose a hazard to human health. We're talking about a drop in eye drop in an Olympic-sized swimming pool for some of the substances in this family of contaminants. That's how toxic we're talking about here. Yet WMC argues that DNR does not have the authority to regulate it right now unless it goes through this arduous rulemaking process. And that interpretation would turn the spills law on its head and effectively operate as a repeal of that law, because DNR would then have to turn around and promulgate rules that anticipate essentially every circumstance where a discharge of a substance might create a hazard, which is simply impossible. And especially given how difficult the legislature has made the rulemaking process in recent years. So that case, very high profile, involves an important matter of public policy, involves a question of first impression, all different things and criteria that the Wisconsin Supreme Court looks at when taking cases. So this case is currently pending before the Wisconsin Court of Appeals and is very likely to be decided in the next coming couple of months, excuse me. And after which, it being decided, an appeal to the Supreme Court is virtually guaranteed, right? And it may be very likely that the court would take this case. The Court of Appeals may even certify it directly to the Supreme Court. We'll see. Okay, the second case, that case, I'll remind you, involving DNR's ability to require concentrated animal feeding operations to obtain water pollution permits. This is a very recently filed case, I believe in June of this year, but at least this summer, right? So WMC filed a lawsuit, as I said, on behalf of two agricultural organizations over DNR's application of the water pollution permit program, also known as the WIPDES program, to CAFOs. But surface and groundwater quality impacts from industrial farming operations have long been documented in Wisconsin. Significant groundwater impacts in Kewaunee County, including impacts to drinking water wells up there, was the impetus behind the suit against Kenner Farms that we discussed earlier. So current law requires CAFOs with 1,000 or more animal units to obtain a water pollution permit if they store manure or process wastewater in a lagoon that's below grade, or if that manure or processed wastewater will be spread on fields in the surrounding area. But this lawsuit rather alarmingly alleges that DNR doesn't have the authority under the Clean Water Act to require CAFOs to obtain water pollution discharge permits at all. And the way that this case is doing that is by attacking DNR's very reasonable presumption that discharges of this manure and processed wastewater to surface and groundwater will necessarily result from the operation of large CAFOs. We have these drinking water and groundwater issues for a reason. So this is very alarming, but this case is still in its infancy. It was just filed up in Calumet County and is pending before the circuit court up there. And briefs on the merits haven't even started yet. That's how new this case is. But it is extremely alarming and very problematic, and especially for folks who rely on groundwater for their drinking water and live in close proximity to these facilities. So depending on how this case proceeds and how it gets appealed and advances through the court, this may also be destined for the Wisconsin Supreme Court in the next few years. So the takeaway, I think, from those two are that they're just two examples of assaults on DNR's authority that may be decided by the newly constituted majority of the Supreme Court in the coming years, and that are very likely to have a profound impact on the state's ability to continue protecting the environment and public health from toxic substances in the way that we've been accustomed to. Tony?
Yeah, thank you so much, Rob. So we're coming up on the top of the hour here, and the last overarching trend that we want to discuss with you as part of our presentation here is the issue of gerrymandering. Probably everyone on the call knows that partisan gerrymandering is the act of legislators redrawing maps to gain a partisan electoral advantage. And it's the idea that politicians pick their voters rather than voters selecting their representatives. So the history in our state is that between 2010 and 2011, Wisconsin went from unified Democratic control of state government to unified Republican control. And because 2011 occurred right after the decennial census, that meant that the incoming Republican majority and former Governor Scott Walker, got to redraw the maps that would govern the state for the next 10 years. And at that time, computer modeling, there's a technological kind of component to this. Computer modeling became more sophisticated to give map makers the ability to draw even more enduring and dramatic gerrymanders to lock in that electoral advantage. So, as a result, the Republicans who were in power at that time created what many commentators have referred to as the worst or one of the worst partisan gerrymanders in modern American history. And what that means, as you see there on the screen, is that even when the other party wins the statewide election, as the Democrats have done in the last two gubernatorial elections, the Republican majority in the legislature is not even at risk. And indeed, the Republicans often are close to obtaining a supermajority, even in those circumstances. If you are interested in Wisconsin politics, you probably already know that. But why is this an environmental issue? And again, I think the historical context, taking a look back at where we've been, is important here because before gerrymandering, the legislature was forced to care about what the majority of Wisconsinites wanted to see. And when we had a healthy legislative democracy, when legislative leaders had to care about the values and the priorities of the majority of Wisconsinites, that meant that historically the legislature was a good environmental steward, passing some of the protective laws that we've talked about and alluded to tonight. It meant that we had a state agency in the DNR that was staffed and resourced to be a national leader on environmental protection, as the DNR once was. But we're now well into a second decade of not having a healthy legislative democracy in Wisconsin, and that distorts policy across the board, and it especially distorts environmental policy. And that's because on issues that many of us care about, whether it's protecting natural areas from development, whether it's protecting groundwater, or Wisconsin's lakes, rivers, and streams, whether it's getting real solutions out of the legislature to climate change, or whether it's getting funding and justice for lead poisoned kids, which we'll talk about in just a minute. On all of those issues, there are highly organized and well resourced special interest groups that take the opposite point of view. And because we do not have competitive elections in the state because of gerrymandering, the legislature, as a practical matter, often pays way more attention to what those special interest groups care about and what they want to see happen than the legislature pays attention to what the majority of Wisconsinites want to see happen. And I want to give just one example from our work at MEA, and we could give many examples, but this has to do with the legislature's response to lead poisoning in Wisconsin. And at MEA, we're really honored to get to work closely with the Coalition on Lead Emergency in Milwaukee, COAL, as it's called for short. And that is a coalition that is led by the parents of children who have been affected by lead poisoning. Their leadership is central to the coalition. Many of you may know that lead is a neurotoxin and that it can dramatically impact a child's development and health, especially when children are exposed at an early age to lead poisoning. As part of its advocacy, Cole and Cole parents have been for years now pressing state leaders to do more to address the lead crisis across the state, not just in Milwaukee, by doing things like devoting additional funding to remove lead service laterals from our water infrastructure, to provide more funding to address chipping and peeling lead paint in homes, and to even take simple steps like allow proactive inspections of rental properties to ensure that landlords are addressing lead hazards before lead ends up in the blood of kids. But on all of those issues, the parents of coal and other advocates have been rebuffed by the legislature. And why is that? Well, I think one of the reasons is that for a lot of reasons, lead poisoning as an issue has been pegged as an urban issue. And because of the gerrymander, the people who are in control of the legislature right now tend to represent suburban and rural areas. And what that means is that the inner city Black mothers who are leading coal, primarily Black mothers, have almost no chance to have their state representatives, the people that they elect to the legislature, to be in the majority to help them achieve some of these legislative and policy goals. And realizing that that's the state of affairs, coal parents have actually tried to find allies in Republican districts to help them gain traction with the Republican legislature. As a practical matter, what that means is primarily Black folks from the city of Milwaukee going to talk to folks from the predominantly white areas of the state to try to get the legislature to care about this issue. And there's a tragedy in that. And even that has not worked. And the legislature has specifically said, or legislators have specifically said, that they took money out of a recent budget to address service laterals because they were afraid or thought that too much money would go to Milwaukee. And it's, it's situating this injustice in a larger injustice makes it even more stark because one of the main reasons that lead poisoning predominantly, or I should say disproportionately, affects inner city Black children is because lead poisoning is associated with other forms of racial discrimination. The main drivers of disproportionate rates of lead poisoning have to do with deteriorating housing stock and disinvestment in housing stock and low home ownership rates. And the main historical causes of those trends in Milwaukee are directly related to redlining and housing discrimination. So in some, we had a situation where historically redlining and housing discrimination divided the Milwaukee area to fuel a lead crisis that is currently affecting children in the inner city. And that most impacted community is the most disempowered in the legislature and with the legislature and cannot get the remedies and the resources it needs to address this crisis. And that's just one example of how gerrymandering distorts environmental democracy and leaves our environmental health and well being worse off. That's where we are today. But with the election of Judge Protasewicz, now Justice Protasewicz, I think that election itself by the voters was a small d democratic rebuke of gerrymandering and really a positive demand that the laws of this state reflect the values of the majority of us as Wisconsinites. And just to come back to where we started, at MEA, we're a nonprofit environmental law firm that has the honor to get to work with communities across the state of Wisconsin. And we get to work with Wisconsinites from all of those communities who are doing extraordinary things to defend a healthy environment. And from that work, we know that there's so much that unites us as Wisconsinites across all areas of the state, whether it's the parents of lead affected kids in Milwaukee or the neighbors of industrial farms in rural Wisconsin, whether it's communities like Marinette and Peshtigo that are dealing with PFAS contamination, or indigenous and non-indigenous communities up in northern Wisconsin fighting Line 5. All of those communities are united by their shared love and desire to protect water, to protect the environment, and to steward environmental resources for the next generation. So we are really uniquely situated to know that what unites us as Wisconsinites um, is more powerful than what divides us. And really, what is dividing us when it comes to environmental policy is mainly the legislature itself through the gerrymandered maps. So now the court has that issue, at least a petition to address that issue in front of it. It seems clear that it is very likely that the court will address gerrymandering, and hopefully it will pass judgment on that divide and conquer tactic. Um, as we can look to a future beyond gerrymandering, certainly there will be many challenges that remain for a healthy environment, for a healthier democracy, but we will certainly be closer to a Wisconsin that reflects the love and the care and the concern that most of us have for our homes, our families, and the land, the air, and the water that we all share. And that is what we feel is on the horizon for us as a state. So we want to end our presentation with that note And we're close to the top of the hour here. We did take a few questions from folks as part of the registration. And Rob, if you don't mind, maybe I could just give you a couple of those questions so we can make a good attempt to respond to folks who are kind enough to submit some questions to us.
Sure, and we could always follow up individually too
Yeah,
to
we
those we
will
don't
do
get
that.
to.
If you submitted a question and we didn't, um, we will follow up with you because we've got, I think, your contact information. So one quick one here, Rob, or maybe it's not so quick. One registrant pointed out that there was a newly enacted ban on public referenda that was enacted recently by the legislature. Can this be overturned by the courts?
So I assume this is the ban on the advisory referenda that was included in the shared revenue bill for like counties and other municipalities to include questions, right, to their electorate about all sorts of things. And so the shared revenue bill certainly got rid of that. It was signed into the law. It was a little bit of a compromise between Republicans and Democrats there, but certainly that was one outcome of that. Whether or not it could be overturned by the courts, though, I think that's probably tough to answer definitively one way or another, if only because it's not a strictly environmental law question, right? It's a little um, it's like an intersection of municipal and election law. But what I will say again, that those advisory referenda are non-binding referenda, right? They're not like referendums to the people, like say for a constitutional provision that need to be authorized or something like that. So those referenda didn't necessarily carry a whole lot of weight with them anyway, but certainly the idea that you would stifle that sort of exercise of free speech opportunity, I think is certainly problematic. Trying to think, certainly there could be maybe an argument for certain types of municipalities like cities or villages that impacts their home rule authority, but that may matter on how the ban is written. If it's uniform and applies to all municipalities, it may actually pass constitutional muster there. Doesn't mean that a more responsive legislature wouldn't think or rethink that, though, in the future.
Thanks, Rob. Well said. Um, why don't we go with just one additional question, which is how can we bolster the Department of Natural Resources' ability to protect itself from litigation from polluters? And this was from Joseph at the Crawford Stewardship Project. That first question, I should say, was from Lindsay Davis, who does work with River Alliance.
Yeah, thanks for that question, Lindsay. Joseph, you said?
Yep.
Um, so how can we bolster DNR's ability to protect itself from litigation and from polluters? Well, I would be remiss if I didn't have a shout out here to my colleague, fellow MEA staff attorney Adam Voskuhl, that always reminds me that anyone can sue anyone for almost anything, right? Now, whether or not the lawsuit is successful is a different question, right? But from these real challenges, right, in these litigation that it sees time and time again, especially from powerful industry groups, right, it is a big problem. And I think in the first instance, right, we can push back these current attempts, right, to erode their authority and vindicate that authority from the laws that DNR has always implemented, right? And that means winning cases like the spills law case we talked about earlier, that CAFO WIPD's permitting a case out there. But also, I think it's important to see what happens with the maps, right? Because we need a more accountable legislature so that we can repeal laws that folks have been enacted recently and that folks have been pointing to as potentially curbing DNR's authority, right? And or passing additional laws to shore up or provide them with additional authority where things like PFAS wreaking havoc make plain that they need more of it, not less, right, to adequately protect folks here. And I also think they just need more resources to defend themselves and make good decisions in the first instance. And that's not only DNR, right? Who often represents DNR in court, right? That's the Department of Justice, right? So they also need their attorneys to be well resourced and ability to defend them as well. And I also think that we need to take a serious look, right, at the limitations on DOJ's ability to settle, because I think that has a huge impact on outcomes, right, that are achievable and may even dictate, depending on the case, what enforcement action that DOJ brings in the first instance. So anyway, I think those are some examples there. But yeah, we have to win the cases that are there and vindicate their current authority, and then try to go out and get some of it back with a more responsive legislature.
Thanks, Rob. There was one other question in the chat, quick question that I want to answer from Mike Goodman, who asked about why on the lead map that was shown in previous slides, some of the data was withheld. And I believe the answer to that, Mike, is that in a few census tracts, there were so few lead tests conducted in those census tracts that it was considered potentially identifying information for the children who were involved. That one could look at various sources of data and potentially trace back the identifying information of which child had tested positive for lead poisoning. So it was a HIPAA thing related to limited data from those census tracts. Well, I don't want to keep us much past the top of the hour here. And what I want to do before we close is again thank everyone for attending. It is so great to see so many people here and so many people stay on for a full hour between 7 and 8 talking about the Wisconsin Supreme Court. That's really inspiring. And before we go, we want to remind you that coming up, we have our Environmental Justice Awards, which is October 26th, also at 7 p.m., where we will be honoring three amazing award winners, including Deanna Branch, who is a coal leader, Lisa Dorr from Northwest Wisconsin, and Maria Powell from the Madison area. So please register on our website to join us for that event. It is always uplifting and inspiring. With that, again, I want to thank you for joining us and for your attention and for all of your support of Midwest Environmental Advocates and our mission. Thank you.